Broadcast is now starting. All attendees are in listen-only mode.
Hello, and welcome to today's webinar, Exempt and Non-Exempt Employees, presented by our sponsor, Heffernan. We're so happy you can join us. My name is Deb Beto, and I will be your moderator today and be monitoring questions you may have during the session. Before we open up the session, let's review a couple of key items. All of the webinar materials we discuss can be found at the URL currently showing on your screen. I will be sharing this URL in a follow-up email, so don't feel like you need to write it down right now. If you have trouble with your internet connection during the webinar, we recommend leaving the presentation and logging back in. If you have audio difficulties or a telephone line goes dead during the call, hang up and call back again to the same number. If all lines go dead, watch the on-screen chat box for an alternative call-in number. Please feel free to ask questions or provide feedback by using the chat box or questions box during the webinar. If you are using a tablet, you may need to tap on the screen for the options bar to appear, and then you can select the appropriate option. We may not respond immediately, but we will try to work your questions or feedback into the presentation. If we can't get to your comment or question during the session, we will be online afterwards to respond, or we may follow up in an email if we run completely out of time. You may also email us at moderator@aspenrmg.com for up to 48 hours after the webinar. This will be a 1-hour presentation. Questions and comments are very much encouraged throughout, and the presenter will be answering questions throughout the presentation as well. And lastly, we have a number of webinars upcoming covering a variety of topics, including those listed at the Heffernan webinar website. In addition, we offer the mandatory Preventing Harassment training in English 3 times a year. With that, let's begin today's webinar, Exempt and Non-Exempt Employees, where you will learn about FLMA, overtime, travel time, leaves of absence, and other important distinctions between the two classes of employees. Today's interactive session will be facilitated by CJ Westrick. CJ Westrick is an SPHR, and she has been in human resources management for over 25 years and received her senior professional in human resources national certification in 2002. She started HR Jungle in 2006 and targets companies that want senior level HR expertise on a part-time basis. HR Jungle provides business owners and management teams workable solutions and hands-on assistance with employees and legal compliance through outsourced HR services. Welcome, CJ.
Thank you so much, and welcome everyone. Today, we're going to be talking about the definitions between the exempt and the non-exempt and the different exemptions available, and the penalties when you don't classify properly. But first, I always like to start with a little bit of news. It's like, scary kind of stuff to keep in mind. We have Deja Vu Consulting, and they got hit for $6.5 million because of minimum wage violations. They had classified them as independent contractors, but I've also seen the same thing happen as they classify them as salaried employees. And so this is the kind of thing the EEOC goes looking for, the Equal Employment Opportunity Commission, which is the federal department that handles this kind of stuff. Zenefits, which is a benefit company, they do benefit and they've got software and stuff like that, but they got hit for $3.4 million in unpaid overtime because they had misclassified a bunch of their account executives and sales reps. And then we have T-Mobile, $19 million for off-the-clock work, unpaid overtime, missed meal and rest breaks. And those kind of charges only come when someone's misclassified them, as a rule. I mean, I guess there are times when somebody's still classified as non-exempt and they just don't get paid for those things, but often it's because they were misclassified. So let's look a little bit at what some of the options are available. We have executive, and these are federal exemptions, so it's not like each state has a chance to play with them. It's executive, administrative, professional, outside sales, commissioned inside sales, and computer professional. So we're going to kind of go through those and talk a little bit about them and how you would decide whether or not you have somebody that meets one of those exemptions, I'm sorry. But let's start off with our first polling question.
All right, so we'll launch this. How much weight does the title carry in determining whether an employee is exempt or non-exempt? It's either 25, 50, 100, or none. And again, if you're using a tablet, you might need to tap on the screen in order for these options to appear. And I always like to wait until we get about 80% of the people that have voted so that I can make sure that people are actually paying attention and participating, because the more you participate, the more you learn. And so if you would please use your voting right now. And don't forget that if you have questions during the session, you can use your questions box or your chat box to talk with me. All right, we're at about 70%. So as we go, I'm going to be looking for a little bit better participation. But right now, CJ, we have 15% say 25, 17% say 50, 11% say 100, and 56% say none.
Well, it's none. So for those of you that picked one of the other options, keep that in mind. The title makes absolutely no difference. You can call the person a CEO and it won't make them exempt. So keep that in mind. It doesn't matter if you're calling them a supervisor or a manager. It's always going to be looking at two things. One is each exemption has a minimum salary that must be paid. So that's always the easiest test right there. But the harder test is the duties test. And that's where it gets into quite a bit of discussion. But bottom line is all employees are considered non-exempt, which is like, normally you pay them hourly, unless you can prove otherwise. And so you need to also give some thought that if you're doing an audit of your employees on their exemption qualifications, you might do this under the privilege protection from your attorney, because otherwise what you have are, now you've got documents that can be called into court that shows that, oh, last year you did an audit and you knew this person should not have been exempt, and yet you kept them exempt. So that's why, at least if it's under the umbrella of your attorney, that would be protected. And so the attorneys always recommend this. And I can understand, because of the fact that court cases do have a tendency to pull in a lot of information companies may not want to share. So let's move on, find which button makes me move down to the next one. So a non-exempt is usually paid hourly. And it's, like I said, everyone out there that's working, unless they meet the exemption tests. So a non-exempt person is paid for overtime hours, and how that overtime looks varies by states. California has this weird, I think only California has this one that says overtime is anything over 8 hours in a day or over 40 regular hours in a week. Most states it's just anything over 40 hours in a week. A non-exempt person must be paid at least minimum wage for your state, and the company controls the hours and the work that they're doing. So for most part, having someone non-exempt gives you a lot more control over their behaviors at work, on exactly what you want to do. And as a rule, non-exempt people are a little more task-oriented. They may have a certain list of responsibilities, but it's inevitably going to be inside a box. These are already predetermined on what their options are going to be in choosing like which thing, because I've had this argument a lot of times where, oh, but they do make decisions, but they're not making out of the box decisions. They're picking from A, B, and C that you've given them to pick from. And so that makes a big difference when you're looking at a non-exempt person. They are not able to just go and do their own thing completely. They need to get authorization from someone else. When you look at exempt, these are people who are exempt. That's the whole point of the names. Exempt from overtime pay, and if you're in a state like California that has required meal and rest breaks, then they're also exempt from that. I always tell people in California, they don't care if an exempt person ever eats or sleeps. It's like they're an exempt person. So you need to be careful with an exempt person that you should not be doing comp time. Calm time is when, oh, I had to work on Sunday getting ready for this big show we're doing, or I had to like fly out to go to this thing. And so why don't, I'm just going to take Friday off as comp time to make up for those hours I extra work. When you start counting their hours, you're making them a non-exempt employee. The whole concept of an exempt person is it doesn't matter if they work 2 hours that week or 80 hours that week. And then they also, so as I mentioned, they have to meet the salary minimum that's listed on the exemption, and it's going to tell you what the minimum is, and they must meet the duties test of the particular exemption. It's not just thinking that they're going to be exempt. You have to actually select a particular exemption that they qualify for. One of the big things that all exemptions typically say is they are customarily and regularly exercising discretion and independent judgment. So this is where I was talking about making decisions within a box. It doesn't happen that way. These are people that truly have authority and power to make a company decision. So they can choose to sign away the company is going to spend $50,000 on this piece of equipment or in this particular direction. And some of this, varies a little bit with each exemption, but the biggest thing is to remember that it has to be a significant kind of decision that they've got authority to handle. So when we're looking at titles, often these are going to be, it'd be rare that someone would have a CEO or a VP title that doesn't have this kind of authority. Even a director level, I have seen director levels who did not have the authority to make a decision without the CEO's permission and authorization. So that's why we say titles make no difference, because it really depends on the amount of authority the management team has been given. And because I worked with a client years ago where the CEO, he was like his own worst enemy because he was the bottleneck because everything had to go through him. And, when I talked to his directors, they're like, we can't make any kind of decision. We can't even hire somebody without his authorization. And so they had no power. Therefore, they shouldn't have been exempt. You have to do that. It's like if they're just doing task things, or again, if they're working strictly inside a box where there's not any wiggle room at all, they're not making the level of decisions they need to be making to be exempt. So we're going to start with the executive exemption. This is the key personnel. Usually it's going to be your C-suite, your chief executive, your chief operating officer, your chief financial officer, all those people that have the chief in front of their full title. They are the ones that usually are running a whole company or a department. And usually they are directly managing at least 2 full-time equivalent employees. So that means 80 hours worth of employees. They've got the power to hire, to fire, to change the status of employees. You could say, oh no, I'm demoting you, or I'm going to give you a promotion. Sometimes it might be where their restriction is within their budget, but otherwise they don't need a secondary approval for doing that. And the big one here that falls apart so many times is that, and this is one you'll see on almost every exemption, they have to spend at least 50% of their time on what is considered exempt level duties. So they're hiring, training, evaluating, and firing employees. They're controlling the flow, distribution of products. They might be planning and directing the work for their department or for the company. They're setting the pay rates and the hours. They are making decisions that affect other people and affect the company's bottom line. So that's the executive one. The most common one is the administrative, because it now drops down a little bit. And this is often where you're going to see more like the directors or managers, and sometimes even a supervisor title in there. But it really means that they are, doing things that it's related to policies or the general business operations and, or the customers. And they do have that discretion and independent judgment requirement. So when you're looking at who the employees are, they are usually, we'll call them functional rather than department heads. They may not be, the vice president of manufacturing, but they might be, the manager that's operating, running the manufacturing line and stuff like that. They need, they're using their specialized training, their experience, and their knowledge to do their work. So it's not somebody who just newly comes in that doesn't have the ability to do this. The education is rarely a true consideration in something like this. It doesn't matter if the person has a PhD. It matters what their duties are. What are they handling? What are the responsibilities? And I will say that, oh gosh, it's been probably 4 years ago that the federal government was trying to change these exemptions and bringing them up because they have been badly misused to where people at much lower levels than they should be are made exempt. And so they wanted to say that, okay, one of the things that came out when they were talking about this was this, I don't know if you remember this, but they were trying to make the minimum salary for anybody at $47,476. And it got passed. In fact, it didn't get shut down until a week before it was supposed to be implemented. And mostly that was because in the South, where minimum wage is much lower than like California, this was a huge difference. It was like more than twice what they had to otherwise pay, what they had previously had to pay a salaried employee. Because in some states where it's a low minimum wage, minimum salary might only be, low 20,000s. And whereas in California, like California right now, the minimum salary is between 50 and 55,000 basically. And it goes up every year with minimum wage going up. So it's, they were trying to make it so that because they realized that if people are paid more, there's more likelihood that they're actually taking on the level of responsibility that the government intended for these exemptions to apply to. That's a bad sentence, but hopefully you get the idea that they wanted that. And then they also brought up the question because it's been kind of a common thing to where as long as you have at least two people reporting to you, you might qualify. But then the Fed said, well, what happens if one of those people goes on vacation? Now you've only got someone at 40 hours reporting to you and you don't qualify anymore. So they really want to, they really were trying to make people understand that to be exempt, you needed to be a much higher level than what a lot of companies were putting people in. And, that you had more than just two people reporting to you, that you were paid way above the minimum salary required because of the level of responsibilities you held. So we're going to move to our next polling question.
All right. Is your executive assistant or administrative assistant exempt? This is a yes or no, or only the executive assistant. And while you're answering that question, we have a couple of good questions that came in from the audience. In the event that you are going through an audit, what happens if you had said that someone was exempt under the executive exemption, but they turn out not to qualify for that, but they do qualify under the administrative exemption? Do you get, is there that level of granularity in an audit?
There is, but it wouldn't have any major effect. So it's like, because the biggest thing is whether or not they qualify for any exemption. That's where you're going to have problems.
Right.
So if you put them under executive by mistake, it's not like you're publishing that anywhere that they're under the executive. If you ever got audited by an outside agency, you'd want to be able to justify where you have each person, which exemption you're using on each person. But it's something that's just easily say, oh, no, they should have been under the administrative exemption, not the executive. So so that's not a biggie, but yeah, I think I'd be clear just because they're, I'm sorry, go ahead.
No, I'm sorry, CJ.
But I think you just want to be clear because there are some little differences between different exemptions. Those are fairly close together, but I think executive, you're better off keeping it to your C-suite, maybe VPs, because they're running like whole departments and stuff. But administrative is, like I said, the most common and is an easier one, I think, to fit people into.
Got it. But all the auditors really looking for is exempt versus non-exempt. They're not looking for the different classes of exempt.
No, you want to know which exemption you're putting them into just because if you need to be able to justify it and say, look at, here's what it says for this exemption and here's why they meet that.
Got it. And why is it that we can get a purchasing manager under the admin exemption, but a sales manager can't be exempt? They both manage people and processes. It's just whether they're working with inside or outside people.
I'll go through some of that because it's that's kind of under what I've got coming up under working
Okay.
managers, because sometimes the field, managing salespeople isn't quite the same, and then maybe a purchasing manager. So it really kind of depends, because if they're truly exempt, it shouldn't be hard to put them under one of the exemptions, and that's the big question always, because this is always a huge bone of contention. I have that issue. I had it when I was working inside. I have it with clients, because it's so easy. It's much easier to have them exempt. It's like not when you get audited.
Okay, well, we'll look forward to that material in the presentation coming up. As for our poll, we have 14% say yes, 70% say no, and 16% say only the executive assistant.
All right. As a rule, an admin assistant is not going to be exempt, because they're not necessarily having people report to them. It's like, what exemption are you using? That would be the big question. So administrative duties. So when they're talking an administrative exemption, this is an example that the feds have provided. Here's, that they're advising management. Yeah, but on what things? Are they matters of huge to where it's, they're going to make a decision based totally on what you've said to them? Like if I went in and said, here's what I think you need to change in this policy, they're going to go, okay, go ahead and do that. They're not going to say, all right, well, we're still checking other people. Are they doing planning and strategy work? Are they negotiating deals for the company? Are they representing the company out there in some fashion as being the one that can be signing on that contract? Same with the purchasing materials, are they got a signing authority? I've worked with companies to where there's this grid that says, okay, here's the level of position and here's the level of their signing power. So like an office manager might be able to sign a purchase order for up to $2,500 because they're constantly replenishing the office supplies. Whereas a VP might be able to sign up to $50,000 before the senior management needs to kind of talk about it, because that's going to be a big hit to the budget, and so there's levels like that. And you need to look at that when, it's like if I worked with a client where they had just acquired a company, and one of the people in the company they had acquired resigned after a week. And he told me, he goes, if I have to have the CEO sign off on a purchase order for a $15 desk item, I'm in the wrong company. But it was a sign of what that company was like. The CEO managed everything. Nobody else could sign off on something like that. And, so, you've got the promoting sales, and stuff like that, marketing management, researching business opportunities, analyzing the business data, and determining company or personnel policies. So these are levels that are a little higher than just you're developing them versus you're following them. And I think that's a clear definition. If somebody's just following policies, and that's where I'm saying they're working within the box that was created. And it may have a lot of wiggle room in there, but they didn't create the box. And you really want people that are exempt creating the boxes. So here's some examples that the feds have provided. An exempt person is a financial consultant who's working for a firm, an accounting manager, an HR manager. And often that might be because, accounting manager, because they're actually running the accounting department. Same with the HR manager. And, but typically people who are not exempt are often those that are called supervisors, because they don't have enough authority. They're just managing some people, but they're not doing the duties side of it as well. Office manager is usually not really going to be an exempt person, because again, they're working within the box. And then the executive and administrative assistant. And it's like, I don't know if you guys ever remember, there were like old movies from like the 30s and 40s and 50s to where an executive assistant at that time was often a man, but they were literally the CEO's right-hand person. I mean, when that CEO went on vacation, this person made all the decisions for the company. That was an executive assistant. Over the years, these titles have gotten diluted to where now it just means it's an admin who happens to be working for the C-level people. But they still don't necessarily have the level of responsibility, the level of authority to make policies, to create them, to sign off on things. So that's where you have to kind of start thinking through that. There's far fewer people who should be exempt than are. And it's a common issue out there. And some of it, I mean, I've done some of these audits for clients before to where they'll finally say, it's like, okay, I know this position now should be non-exempt, but we've had it like that. We've got 6 people in that as exempt. We're not going to change it. And it's like, and for me as an consultant, that's their choice. But I also want to make sure they understand the risk they take in doing that, because I have also seen that side of it, and it's not pretty. Let's move to polling question number 3.
Okay, I will launch it right now. Is a manager with 2 employees usually exempt? Yes, no, or not sure? And we have a couple more questions that came in. If the company has to pay overtime for non-exempt employees who work on weekends for company, does the company have to pay overtime for non-exempt employees who work on weekends for company charity events?
Yes, I won't say it's necessarily overtime, but they have to pay for that. It depends on how you position the event. If you're saying, oh, the company would like to participate in this event over here, it's not going to, I mean, I flat out will tell them it's not going to be paid time, but if you're interested and want to volunteer, here's where you sign up for it. You want to make that very, very clear that you're not intending to pay for it, and that nothing, because nothing will be held against them if they choose not to do it, because it's going to be on their own time. I have one client that does, they don't have a winery, but they do finish off, we'll say, the wine in barrels. And they actually invited some of the employees who wanted to go up to Napa in California to go see the vineyards where they're getting their wine from. And we made it very clear up front, it's like the company's willing to pay for your travel just because we think it'll make it easier for you to, do your job and know where it's coming from and stuff like that, but we're not paying for the time. And as long as you make it, and be very, very clear, it is a voluntary thing. You can choose to do it or not. We're not going to hold it against you, but you want to be extremely clear. The overtime part of it is just depending on your state and how you calculate overtime if you are doing the paid time. But if you make it very clear it's a voluntary event, the company's putting together, and anybody who wants to is welcome to come. It's kind of like those freeway cleanups, it's like they're not forcing people, or if they are, they're paying those people.
Okay. And the definition of exempt, especially when it comes to administrative duties, it seems like the definition would also need to meet the salary test. Is that something that we're going to be?
Every exemption has a salary test and a duties test. The salaries test is typically going to be 2 times minimum wage in your state. Not minimum wage like in California. We've got I think it's 30 localities now that have different minimum wages in the state, but the federal exemptions only look at the state minimum wage, which is why in California right now our state minimum salary is, like I said, it depends on, they've got an under 26 and 26 and more numbers, so it's right between 50 and 55,000, I'd say, as a minimum salary for anybody who they're saying is qualified. And yeah, I will go a little bit more into the money of it. And let me see if I actually do. Well, I don't so much. Anyhow,
Okay.
You're always looking at 2 times. Yeah, you're always looking at 2 times your state minimum wage.
Okay.
And it's never prorated. So even if you've got someone you're calling exempt and they only work 1 hour a month, they are still going to need to meet that full minimum salary. As I said, nobody cares how many hours they work. It's did they get the job done?
Okay, good point. And I'm going to do one more question before we release the polling question. And then we have more questions that have come in, but I'm going to save those for later. Can the company deduct hours from exempt employees?
Yes, but you want to be very careful, and you want to check on your state rules. It's like if they, in theory, if they work any time in a week, you owe them for the week. But I've also seen, like in California, the labor commissioner will say if they are absent for a full day and you've got time available on your PTO or vacation or sick leave policies where they still get paid for it, that's fine. But if they're out of that time and it's personal time off, then you might be able to deduct that. that from them, but it becomes very much a state issue, not just a
Okay.
general issue.
Excellent. For our poll, we have 45% say yes, 29% say no, and 25% are not sure.
And for the most part, it varies on the exemption. I will say that, because administrative is based on, and executive is based on having people report to you. But administrative also would allow, like, someone who has a title of an HR manager and manages the whole HR function and is at a level where they are creating policies. So it's not just because they're like the only HR person there, because I've got a lot of clients where they have someone they've called an HR manager who have no true knowledge of HR, and they're not making those kind of decisions. So it kind of depends. Again, you don't look at the title so much as what is it they're doing? Do they meet the minimum salary? And are they making those kinds of decisions? Are they really having, some kind of authority? And, like when I worked inside, I would write the policies and, get the nod from management. Yeah, go do it. And, things like that. And so you have to kind of break it apart. Is it someone who fits more like this working managers, where this is, I think the title might have even come out of Starbucks for working managers because of the lawsuits that they're constantly dealing with. And that was one of the things. They've got, shift supervisors, but it turns out that those shift supervisors are in fact spending a lot of their time doing the same thing as the other employees. So they're not spending over 50% of their time actually doing exempt level work, because there just isn't anything. Everything at Starbucks locations, it's like it's preordained, shall we say. It's like they all have their little boxes that they work inside, and they're not necessarily doing, maybe whoever owns that franchise, if it is franchised, but otherwise all the decisions really are coming out of headquarters, and they're just following the policies inside that thing. And so you look at working managers, this is where a lot of times people called supervisors are landing, is that they're really doing the same work. They have a few other responsibilities, like maybe they're doing the scheduling or, things like that, but they're not necessarily spending 50% of their time on those duties. And, they often are just managing, a few employees, which again is why we call them supervisors instead of managing, the bigger umbrella, like the bigger department or something like that. And, so you're looking at what kind of managerial duties do they have? What is the frequency of them having to use their discretion or independent judgment? And is it something that's inside a box? Like, okay, I know I could make a decision of doing this or this, and here's what I'll choose. That's not independent judgment. Independent is saying, wow, I'm going to go ahead and suspend this person for 3 days unpaid. And the company doesn't have that as one of the two obvious choices that they would have you select. That's more independent judgment. And so it's the person needs to not only just make those, but to be authorized to make those. And that they're, pretty much free from supervision. A working manager is someone who usually is going to be maybe given, we'll call it a task list, maybe on Mondays. It's like, okay, here's what I need your team to, work on this week. And they go off and they do that. So these are people that are called leads, like in construction, they're often leads. They might, be a supervisor title, and but they also need to be making, a little bit more. But a lot of times I find the working managers aren't making enough to qualify them as exempt either, because the people that give them a supervisor title aren't yet ready to put that kind of money out there for this person or this position, which means that they don't have authority either, because it's either, they have to meet both the salary and the duties tests. It's never one or the other. It's always going to be both. When we look at the professional exemption, this one it's easier, but it's not. So it's 3 basic categories. It's called learned professional. So this is someone who is degreed and had to be degreed to be able to get that job. Or licensed. Attorneys are licensed. CPAs are licensed. They're licensed by the state in order for them to do the job. And then you've got artistic, and I've bumped into this one several times with some clients. Oh, I've got these graphic artists that do this stuff, just from home for us and everything like that. But they're they meet the artistic. And it's like, no, when they say artistic, it means artistic. You're talking museum people, the ones that are doing a lot more. So let's go into some of these. And there is a salary test for these people. The federal is at least 30, this is the new federal minimum. They brought it down from that 47,000 or almost 48,000, and it's 35. But again, in the southern states where they have a lower minimum wage, this is a higher number for them to hit, because like I said, I remember a few years ago, it was only like 21, 22,000 that they had to hit. So this is a jump. And so I think it's the feds trying to roll it up higher. But if it's either to meet the federal minimum, if you have no state minimum, and just follow the federal, or it's the state minimums. So when we looked at the learned professionals, it is an advanced degree. It's not just a bachelor's degree. It's usually going to be usually it's going to be like the doctorate, but not always. But, we're talking certain fields, law, medicine, theology, accounting, engineering, the sciences. And, they consider it to be part of a prolonged course of specialized intellectual instruction. And the work itself is often mostly intellectual. And, it's funny you say the higher the level of the person, the less actual work they do, because they're thinking. And, so if you think of like an attorney, they are using what they know to develop the argument to put in court, or to help you, with something you've got an issue with. And it's brain work, kind of like what I'm doing now. It's like I'm not out there doing the HR work inside a company, but I'm the one that gets the phone calls from the company or even the HR person saying, okay, we have this issue. What can we or should we do about it? So I'm having to think through what is the issue? What else, what are all the pieces of it? Here's my, opinion on it. And, and they have to meet the minimum salary test. So that's for the learned professional component of this. Then we have the licensed, and law actually kind of fits both of those characteristics. So there's only certain fields that meet the licensed professional ones, and these are ones that require a state license to be able to function at all. So these are the only fields it works for. It doesn't matter if you've got a license. I don't know, there's some, it's more you get certifications in some other fields. But in these, for certain positions, you have to have a license. You can't practice law without a license. You get somebody who hasn't passed the bar yet, they don't have a license yet. So they can only do background work for an attorney. Teachers, both the attorneys and the teachers and the doctors have no minimum salary. And so that's why a lot of times you'll see teachers that unfortunately are underpaid, because there is no required minimum salary, and yet they can be an exempt position because they're licensed. Dentistry, you wouldn't want an unlicensed dentist working on your teeth. Optometry, and so there's these fields where they have to have a degree. Well, mostly we're just saying they have to hold a valid license, and it has to be a required license. They can't operate in that role without having a license, because there's levels. You'll find that there's levels, like in medicine, degreed interns and residents have to get a license before they can actually practice. So even though they've gone through the schooling and got their degree, if they didn't apply and get their license, they still can't do what they just trained to do. Then you've got, there's some exemptions in here, and under the professional like this, usually what these roles are, pharmacists, nurses, physicians that are paid hourly, are not automatically considered exempt. It's going to go back to what they're doing. If you go to your local Walmart, CVS, Walgreens, pharmacy, usually you've got the pharmacist on duty, and then you've got all those other people back there that are putting the prescriptions, together. And so it's that pharmacist that maybe, because they're running that department now, or at least they're the one running that shift, that might be considered exempt. But the other people aren't, because they don't have the responsibility. They're just doing tasks. Same with nurses. There's certain levels of nurses, like a physician's assistant will often be exempt because they are actually signing on prescriptions. They're doing things at a higher level than the other nurses might. And you've got some physicians that kind of just put themselves out there on an hourly basis to work with, different other, medical centers or things like that, but they're not really running it as, their whole life. And it kind of just depends how they're doing, because there's a lot of physicians that are set up as their own, corporation and all this kind of thing. So it really moves around there, but you need to look at it. You don't go by the title. You look at what they're doing. The artistic, as I mentioned, we're looking at people who truly make a living out of what they're doing in a way that it's completely their own thing. So that's why doing graphic arts and stuff can work, but it depends on what you're doing with it. If, like my client that said, oh, well, they're creating ads for me, not necessarily being creative, are they? They're just kind of duplicating stuff within a box of what this client needs, as opposed to, you look at all the great artists out there that have ended up in museums. It's their imagination, their originality, their talent that's actually making them exempt. And and so it can be actors, because if they work inside a box, they're usually not going to be terribly successful, because they're like stuck in one role. That's the only one they know how to do. You got musicians, not bands so much, musicians that are part of orchestras or something like that. Now, there's some musicians that might qualify, even cartoonists, that it's when you're creating it on your own, you're not just illustrating for someone else. Novelists, they're creating things from their brain. And again, there is a minimum salary, and a lot of these fields are not paid that well. So it is an interesting one, but a lot of these positions aren't under someone else. They're not working for a company per se. So that's why, the minimum salary and whether or not they're even need to be exempt or non-exempt doesn't even count, because they're just doing their own thing. Moving to our next polling question.
Sorry about that.
Hello.
My microphone there for a second. All right. So, is a sales rep who spends most of his time doing virtual demos of a product or making calls to prospects from a home office exempt or non-exempt? So this goes back to the questions that we were having earlier about salespeople. So we'll get into that. And we're getting a lot of really great questions that are coming in. I'm only going to ask a few right now, and then we'll save some for later too. Let's see. We're getting so many. I just have to scroll up here. If there are so many loopholes in the administrative exemption, is there a specific qualification that can clear it up?
If it were black and white, we wouldn't have so many questions about it. And,
Right.
and it's like because I would love to have something that says black and white, like, this is what it needs to be. But because there's only a few exemptions overall, and it covers like every type of industry and company out there, it's the feds have been, I think, reluctant to be able to, I don't know if it's reluctant or just it's next to impossible to put some very specific things in there, like, does this person, hire at least 5 people a year, or do this or that. And the roles vary so much on what might qualify. I think there is no black and white to it, which is why it becomes not only within a company such a bone of contention, but legally, it's a litigious argument on what meets and stuff. And I'll get into the penalties. So when you misclassify, what happens, and because that's coming up soon. And that's usually your big danger zone. And that, I think, going conservative is usually your best policy. If you can't absolutely show that this person, without a doubt, meets the exemption, don't go there, because the penalties are horrific.
Okay. And if you have an exempt, or if you have an employee that meets all of the descriptive qualifications for being exempt, except that their salary requirement isn't being met, should they be considered non-exempt or exempt?
Non-exempt. You have to meet the minimum salary, and you have to meet the duties test. If you don't do both, it's going to be a non-exempt person.
Okay. And in a small professional firm, if administrative assistants are able to contract for the company and can make official filings, why wouldn't they be considered exempt? If they have significant authority, would it be better to change their titles or justify their roles?
I think like I said, the title isn't so much the thing. It's like, but when you say, make filings and stuff, but the filings are in a box. You know exactly what you need to fill out based on this one, and you go and you do that. You're not the person who's going to go in front of a court and argue that filing. Or if you are, then yeah, you kind of go up there. But I know if we're talking like in a legal office, they often have their office manager. Sometimes it's even an attorney who handles like their day-to-day stuff. But and the title isn't really the thing. But keep in mind that if you're not able to take it to the next level and truly commit the company, it's like I always say, it's like if you aren't able to sign something that's going to potentially cost the company like $10,000-$20,000, you probably don't really have the authority that the feds are looking for.
Okay, so I'll
So,
save some other questions for later. As for our poll, we have 28% say yes and 73% say no.
I have this discussion with attorneys frequently, and what I keep being told on several different fronts is the laws have not kept up with technology. And an outside salesperson right now, it's extremely hard to have anybody qualify for the outside sales exemption because of the pandemic. Because legally, to meet this exemption, they must spend 51% of their time literally out in the client and prospects' offices. You're out knocking on doors, pounding that pavement. You can't qualify the Zoom meetings. You can't qualify the sitting in your office making calls. You literally have to be out there knocking on doors. This is like the old Fuller Brushman, sales thing. You have to be out there making those sales. And the virtual selling and working from home does not count toward this. So I am seeing a lot of people being called an outside sales rep and thinking they're exempt, not qualifying anymore because they're not spending 51% of the time. I have a client who sells big medical equipment. You can't just carry that around on your back to go knocking on doors. So he does it through, like online meetings. But the attorneys have told me this does not qualify him as being exempt. You have to now pay him as an inside sales rep. So look at that. The feds are very clear on this, that there is not, this is the only exemption where, well, I won't say that you could do a commissions only, because there are some like that. A good sales rep might take a commissions only job offer if he knows that the commissions are unlimited for him. But, there's no minimum salary to be met. But there is the hard part here is meeting the duties test of 51% of the time knocking on doors. Because with, right now, a few things in certain places are opening up and people can go out and about, but sometimes even the prospects don't want to meet with you right now when it's not a necessity. And so these people technically, legally, are not exempt at this moment. And I don't know if the feds are going to give people a break, realizing that it wasn't necessarily the plan. But you've got, it's like I'm finding a lot of clients out there are, and other companies are not making sure their sales reps are truly meeting this exemption. And it doesn't bode well when you know that. It's like, for me, it's like, I want to make sure they understand there is a problem here and it can cost you a lot of money if it comes back. I actually know somebody who had this happen where they had called the person, an outside sales rep, and now, 4 years later, he's fighting it with the state and the feds and saying, no, he should have been hourly employee, getting overtime and all that kind of stuff. So beware that this is the exemption. And so if you've got sales reps, take a look at what they're doing right now and decide how that's going to look going forward, because we're still going to have this pandemic hanging around for the next, at least several months. And what are these people going to be doing? How are they qualifying as exempt anymore? It's a huge problem. So our last polling question.
All right. Do you have exempt commissioned inside sales reps? Yes or no? Everyone should get this right because CJ doesn't know the answer to this one. So I'll ask a few more questions and then we'll save the rest until the end. What are the steps to correct years of misclassification?
I'll go through that in a little while because
Okay.
there are things you really do need to do, and getting an attorney involved is one of them.
Okay. And if you have
And
office in another state, but your headquarters is in California, what state do you use for the salary test?
well, the salary test, well, okay, it's going to be the state the employee works and lives in.
Excellent.
All the employment laws, as a rule, will be where that employee is. So the headquarters doesn't matter, because I usually see it going the other way, where headquarters is out of state and they put employees in California with no concept of how horrendous California is on employment laws.
Right.
And so then you get really messed up that way. It's like you're getting a break if you can put them in another state.
Okay. What?
And let's kind of leave the rest of the questions because I want to make sure we get through the slides here.
Okay.
And we've only got 2
Excellent.
minutes left.
So, for our polling question, we have 27% say yes and 73% say no.
Okay, this is actually an exemption I don't like to use because it's so messy, if you think about it. What it is if you've got an inside salesperson, so you've got that outside sales rep who isn't an outside person anymore. Now you've got an inside sales exemption. The only thing it exempts you from is overtime. Everything else still follows the normal non-exempt. Like in California, that means they're still needing to take their meal breaks and their rest breaks. Now, the trick is the minimum pay is 1.5 times the state minimum wage, and the commissions must be more than half of their paycheck. So the other side of this, and where like Cox Cable, I don't know if everybody out there has heard of Cox Cable, but they got into a huge lawsuit because they were paying commissions monthly, but employees were paid twice per month. And the courts came back and said, no, the first half of the month when the commission's not part of the check, they're not getting their commissions half of their pay. So they lost. So that means that if you're using this, your commissions have to be paid out every pay period along with their pay. Otherwise, you can't prove the commissions were more than half of their pay. So that's one of the big holes here. The overtime thing is nice too, but the one that I think is the killer for this is the accountability on those commissions having to be half of every paycheck. And it is limited to, in California, only companies that qualify for the wage orders 4 and 7 can use this. On the federal side, it's limited to retail establishments. So it's also got those restrictions. That's why, frankly, I don't ever recommend using this because it's more than a half of a chance that you're going to do it wrong. We have a computer-related exemption, and again, rarely does this get used. This actually, I think, started because of the big .com, blast years ago, and a lot of people that were in the computer industry lost jobs and all that kind of stuff. So what it is that there's a huge minimum salary for it. Right now, I think it's around $100,000. So it doesn't require a degree because a lot of people in IT kind of came up, learning as they did it. But it has to be intellectual and creative. It only applies to certain positions. And that's kind of it. It's the systems analysts, it's the programmers, the software engineers. It's the ones creating all that software we use. And, and so it is a different kind of thing. Like I said, I rarely see this used unless you are an IT company and maybe you've got somebody out there who might qualify for it. But I wouldn't use it without having an attorney confirm that they meet the exemption because it's just too hard to meet it. So when we look at like in, the differences in federal law, they only need to meet minimum salary, the normal minimum salary. California, it's about 100,000, and literally every year it changes. And in California, they can actually still receive some overtime pay. That's why it's just so messy. I don't know why anybody wants to go there because I haven't had to use it, so I don't know where the advantage is in using it, I guess is my issue with it. So what happens when you misclassify as exempt? First off, the company, is going to be held for the misclassification. And the problem with that is like, because what they decided was it's the company who you're making that choice. When you offer someone a position, you are the one responsible. You can't let an employee decide if they want to be exempt or non-exempt. That's not an option. It's this position we're putting out there for an ad, or we're trying to fill is an exempt level position. Here's the duty, blah, blah, blah. You are the company, which is why you're making the bad decision if you misclassify. And there are fines and penalties involved, and I'll go through a little of that. And the other side of that is that I've actually had to sit down in front of employees. You talked about what happens when you misclassify, and I've had to sit down because the biggest problem is that you don't know how much time they worked because it was exempt. You never had them fill out a time card. Suddenly, I'm putting, like in California, employment wage and hour laws let you go back 4 years. So I'm putting 4 years worth of calendars out in front of somebody to say, hey, right on here, every day you think you missed one of the required meal breaks, or you worked overtime that you didn't get paid extra for, and you have to pay them out for that, period. That just to get that part of it off the table. It doesn't mean you're not still going to be subject to other fines and penalties. So it's very, very messy. And why you always want to go on the caution side of doing this. So when you look at that, you're paying for any unpaid overtime worked that the employee says that they worked. I know California and other states will take the employee's word for it because bottom line is you have no other proof. You can't prove that they didn't work those hours because you weren't tracking it. If there's a required, paid rest breaks and they missed them, you're paying for those. You're paying if there was penalty pay. California has an actual penalty pay for missed meal breaks. You've got the federal, state fines and penalties because there's all that extra pay that you didn't pay taxes on. So now you get that too, and you're going to have attorney's fees. So what happens to the employee that was misclassified? Nothing. They walk away with that check you just handed them. They have to do nothing. So it's to their benefit to question whether or not they should be exempt. And I've had employees do that before. I've been looking at this and I really don't think I should be an exempt employee, and you're just like, oh no. And so you really want to make people work, you want to make the company be very clear on what is an exempt level. And the way you can fix it, and it's not easy because you can try and bluff. Otherwise, know that it's definitely going to cost you money to fix it. Most of the time, what I find happens is if the company realizes, and you're working with your attorney and you realize, okay, if that's why you work with an attorney. Okay, it's been protected as far as what you discovered. And now how do we fix that? Typically what I find is that, because you can't go back and say, oh, we know you worked, 103.5 hours of overtime or something like that. You don't have those records. So instead you say, okay, we would like to offer you $3,000 because we realized we had misclassified you as exempt. And, we don't, we hope that this $3,000 will let you sign this, settlement agreement, basically, is what the attorney provides you, is agreement that says, okay, from this moment on, we're clean. You're taking a $3,000, you're signing the settlement. We wipe all that in the back off the board. And now going forward, we're setting you up as non-exempt. And that's really the only way you can do it without it constantly hanging over your head, is to pay out, and it could be $500, if it hasn't happened very long or you don't think they really ever worked any overtime. Most of the time, an employee, unless they're starting to question it or are litigious themselves, haven't been tracking their hours. Some do. I'm consistently surprised at how many employees will tell me, it's like, well, I know that on August 30th, this is what happened. And on September 3rd, here's what happened. There's some employees who will track every little thing, that they had happened to them at work. And then you're paying whatever they ask almost. But attorneys can often help pull that number down. If an employee comes to you with a big number, because I've seen them come 3 weeks worth of work in the non-right classification. They're like, it's worth 90,000. It's like, I don't think so. You weren't, that was, working a year would not have given you 90,000. But you need an attorney to argue that and to offer something that's reasonable. But that's kind of what you're doing, is you figure out what number is going to make them sign that document that takes it off the board so they can't come back and sue you. And that's how you fix this. But that's also why, now I will say California has laws that, one they've got right now, but if I tell somebody that this is absolutely an exempt position and it turns out I'm wrong, I could be sued as a consultant. So I'm usually going to go pretty conservative. I want to know. And what's funny is when someone starts trying to justify a position to me as exempt, I'll guarantee you it's non-exempt. Because if they felt that strongly that it was truly exempt and it wasn't, it's not even like a question in their mind. They're not going to take that VP who's running this whole manufacturing department. They don't try and justify that person to me. No, they're trying to justify the supervisor to me. And it's like, no, it's like, if you weren't absolutely sure in your mind, it never should have been exempt. And so you want to, take a look at that. You want to be conservative. You want to make sure. I get so often where people tell me, it's like, well, this person wouldn't take the job unless it was going to be exempt. It's like employees think it's this little crown on their head that they got an exempt level position, and they don't realize it's not an option. That's not for them to decide. The company has to make the decision on what level that is. And, so and I will say one thing, keep in mind, exempt and non-exempt are legal terms. Hourly and salary are only payroll terms. They're not legal terms. So you could actually have a non-exempt person who you pay salary to, but you've got to reconcile it then with a time card every single pay period. So I just don't go there if I can avoid it whatsoever, because it gets too messy and it creates extra work. But, you want to make sure that you're pulling in an attorney when needed to help protect the company. Because that way, if you find it like that, in the end, it's going to be the company's decision on whether or not they're willing to take that risk and keep that person exempt, or just go ahead and try and fix it. And, but I think you're better off, thinking in terms of non-exempt, and what does someone need to be able to do? What does the position need to be able to have the authority to do to qualify as exempt? Okay, I'm out of time. So we can stay on for a while and answer more questions, and I'll let you decide how long we stay on.
Because we got quite a few questions that came. And if people are able to stay for the questions, that's great. If you're not able to stay, we'll be here for about 10 more minutes. And this session is being recorded. We will send out information afterwards for how to access copies of the material. So what rate should we be paying employees who work overtime but fall under professional exemption? Is it straight time or time and a half or double time?
Okay, so the professional exemption, you're meeting the minimum, the minimum salary, which is usually always going to be 2 times your state minimum wage, and based on a full-time position, which is 2,040 hours. So you take, if your state minimum wage is $10 an hour, you're taking 2 times 10, so $20 an hour times 2,040 hours, 2,080 hours, sorry. That's going to be your state minimum wage then.
Okay. And what about nurses? Are they considered exempt or non-exempt?
It depends on what role they play. Some of them that are just being ordered around by the doctors may end up being non-exempt. But there, so there's different levels. That's why that was one of those slides that said nurses aren't necessarily automatically exempt. You want to take a look at them and see how much, are they doing, because they might be one of the, I don't know the qualifications of different nurses, but they might be one of the lower level nurses who doesn't yet have the authority to do stuff versus the physician's assistant who can even sign off on prescriptions, which, only usually a doctor or that PA can do.
Okay. And if an organization has teachers that are staff members, they aren't licensed, but they're certified, and they meet the salary test for the state, can they be exempt, or are they non-exempt?
They're usually, if they're state certified, I think they can be exempt as long as they're meeting, because I think the teachers didn't actually have a minimum salary. Let me look where's my list? And where's my license? So licensed, let's see, yeah, teachers, there is no minimum. So they need to have a valid, one that's required, a license or certification, because I do believe teachers don't get a license, they get a certification, a state certification. And there is no minimum salary for them. So as long as they're licensed and actively keeping their license and working at that field, I think you can pretty much pay them whatever you want.
Okay. And must you pay a non-exempt employee overtime when they stay late to, quote, tinker on projects that may not be company projects?
I mean, if it's something the company is going to benefit from, then you want to control that time. If it's something where they just, I've seen where it's like, we don't care if our employees stay late because they want to use our computer or and they're working on their school projects or this or that, that's fine. But you want to make sure that they did clock out and that it isn't something that they're going to try and we'll say like sell in some fashion to the company later, like, oh, I created the software, and that would be okay. It's like, I created the software. It's like, do you guys want to, pay me to use it? Things like that. But you want to make sure it's very clear that it's not a company pet project that they're working on.
Okay. And are learned professionals such as a biologist that manages projects, collects data on those projects, are they considered exempt even though it's not professionally intellectual or predominantly intellectual? So they're applying and analyzing scientific knowledge. Is that exempt or non-exempt?
It's still going to probably be exempt because I know I've worked with a lot of biotechs and I've worked inside biotechs and stuff. And so usually, because you have your research associates, you have your PhD. So it really depends on what level they are and whether or not they're just making sure an experiment worked right versus, that they're creating the experiment or whatever they're doing and analyzing. If they're the ones now, the experiment has been run and now they're the ones responsible for giving the company the results and analyzing whether or not it worked and that may very well be exempt.
Okay. So I think this one's going to be two separate questions. Are licensed insurance account managers exempt? And what about customer service representatives who may not manage employees, but due to errors and omissions, they could cost the company upwards of $20,000 just by their load?
So I'll answer part two first. Just because you might create a $20,000 error doesn't mean you have responsibility for committing the company to a $20,000 deal. Like I know a warehouse guy that we had once when I worked inside that forgot to put a shipment inside the refrigerated section and $15,000 of new product supplies that we had just ordered went bad. Now, that's not, saying he's exempt level because he forgot to put it in there. Same with, a customer service rep that does, forgets and screws something up. That's a screw up, so that's not a responsibility. Hopefully nobody's got that kind of responsibility to mess up. So it's more the other side because I know an insurance agency, you're licensed, we'll call them, I always think of them as sales reps, but they're licensed producers. Those are going to usually be exempt because they're out there on their own time, doing their thing, but the customer service staff that still stays inside is usually going to be non-exempt, even though they often have to be licensed to be able to help that one person to kind of write the stuff and things like that, but they're not supervising others. They really are working within a box. It's like they're talking to a customer. It's like, oh, I see that you also bought a truck, can we cover that? They're needing to have a license just to be able to have those conversations, but they really don't have the level of responsibility otherwise to make them exempt.
Okay. And do churches have to comply with the same exempt and non-exempt criteria?
Yes.
Okay. As well as all other
nonprofits. Any kind of religious and nonprofit, there are no special carve-outs for you in any of the employment laws that I've found. It's more of a bookkeeping carve-out than an employment law.
Okay. Is there some place that our attendees can get a template of a settlement agreement?
No.
Okay.
It's like,
From your attorney, right?
yeah, I know. Well, because, it's like you need it written for your state, to qualify. Because like in California, there's special little clauses they have to add because of certain California laws, things like that. So you want one that, it's like, I would say talk to, an attorney, an employment law attorney if you can. I know some states, they don't have that as a specialty, like, California has a huge specialty in employment law because of our laws there, but other states are just following federal law, so they don't have, it's not as big of a market, but a lot of them still have somebody who knows the employment law a little bit. Ask them what it would cost, because you can usually get a template from them that you could use more than once. But what I find is sometimes different court cases and stuff will tweak the language in different agreements, which is why I am reluctant to use an agreement that's more than a couple of years old even, because I don't know which laws may have changed something in the way it was written.
Okay.
And, and you want something that's going to hold up in court and make sure that, because the whole point of you paying to get the settlement signed is to get it off the table. Well, if you get a badly written one or use like, a nolo.com kind of thing, you don't know that it's going to hold up, and you kind of not giving yourself the protections that you're looking for.
Okay. Is there a statute of limitations for non-exempt claims?
Well, it kind of depends, like, because usually like in California, it's 4 years. EDD, which is our Employment Development Division, they can go back 4 years. They've been so darn busy, they're only going back 3 years, but that's how far they can go back. So that's usually where you want to figure out in what state you're in and what is the limit for your state they usually consider it wage and hour laws, and take a look at that. If you're just doing federal, it may be less than what California has. But it's going to be, look at your state, because that's where you're going to want to look at. And that's what you would use then to decide how far back or how much money you might need to pay somebody to get them to sign that settlement. And because that's the whole goal, is to get them so that your company is protected going forward, because now you've got it right.
Okay. And CJ, we have about 6 more questions. All the participants are still on, or all the attendees that ask these questions are still on the line. Do you want to finish the questions, or do you want to
Sure.
address
Let's just go through, because that way they've got their answers.
Okay. So does exempt apply to an independent contractor?
Exempt employee and independent contractor are two completely different things. First off, an employee is not an independent contractor, and an independent contractor is not an employee. So an independent contractor is a business who is signing up with you to do certain services for you. So it's a business versus an employee. So completely different subjects.
All right. And I would recommend that you might attend our webinar, the difference between exempt and non-exempt, or I'm sorry, the difference between contractors and employees. Is it possible to have salaried or non-exempt? Is it possible to have salaried and non-exempt position? A salaried non-exempt position?
Yes. Because that's why I said salary is strictly a payroll term. So you could have somebody that, is a non-exempt person, but they never work overtime, and they're going to get paid this thing. The problem is that, you put them in there in payroll like that, but legally, you want to reconcile every pay period to make sure they didn't work more hours, that they didn't have a day off or something like that would affect their pay. And it will not work if you have a semi-monthly pay period, because semi-monthly is 86.67 hours. You'll never be able to reconcile that with an hourly employee working that 6.67 hours. So it could work with a weekly or a bi-weekly payroll, but not a semi-monthly.
Okay, good. That's a good tip. And can an employee change their status from exempt to non-exempt depending on the circumstances? For example, like we're experiencing with COVID-19 right now.
An employee cannot. The company can. I have actually, that was one of my big pushes when COVID first started was, go in there and immediately start taking all of your salaried, exempt positions and turning them into non-exempt. You can keep paying them the same equivalent hourly rate, but that gave company the freedom to cut back on their hours without worrying about dropping below the exemption. And frankly, with a lot of people not even working, they might have lost their supervisory, level exemption, stuff like that. It's like, it was the easiest thing. I told everybody, it's like, go to hourly. When you've got employees coming back and you know that these people can actually take back on their full role, you can move them back to exempt.
Okay, and are HR generalists or higher typically exempt employees?
Generalists usually may not be, because often they're working within a box, and usually you don't see the generalist title unless it's within a bigger department. And so it kind of depends, again, are you the one creating the policies without, being told what to do, or just copying somebody else's policy and just tweaking it? Are you capable of creating a whole handbook, or at least reading one and knowing whether or not it's compliant? Those are, things that in an HR role you're going to be looking for, because usually when you get exempt level, it's going to be usually more of an HR manager title and above. Generalist is used for varying things, so I'd want to look at exactly what they're responsible for and what kind of knowledge do they have. I mean, you could have an HR generalist that has their SPHR, and that, to get the SPHR, you have to have been exempt for at least 8 years. So it's like, it kind of goes hand in hand regardless of the title. So you really want to always look first at the duties. What are they actually doing day to day? I'll tell you, my very first exempt position, and it wasn't even in HR, it was for a business manager for the Department of Molecular Genetics for a research institute. And I was followed around for a whole week by HR. There were like 5 different buildings on the campus I had to go to every day and work with the people. But they sat in my office and they followed me around for a solid week to do their audit on my role before they'd let me be exempt. That's kind of the thought process you go through. If you talk with an attorney, they've got these forms that they have you fill out. How much, list all your duties. How much of your percent of your week do you spend on that, or month, stuff like that. It is a tedious job for the audit, but at least you can walk away saying, yeah, they definitely are or are not.
Okay. And are pastors exempt or non-exempt?
I'm going to probably say exempt, simply because they're typically running the church and responsible for, there's certain responsibilities that, because often I think churches now have like boards or committees that help rule it or whatever. And but they're kind of usually, as far as I know, the top dog in the church hierarchy. And that would make them, even though they may only have like a church secretary reporting to them or something like that, but they are running the whole thing, responsible for making sure that, they're keeping people interested enough to where the parishioners are putting money into the little pot each week, stuff like that. So I would probably lean toward exempt.
Okay. And how about a paralegal?
Paralegals are not, mostly because they're not licensed.
Got it.
It's not a licensed position and they're in law. So that would probably make them non-exempt. And I know that's a field that often gets called exempt. But they're writing things up, and doing research. But again, they're not the ones out there arguing the case or making the final decision on, talking with the client about how we're going to go forward with this.
Okay, last question. Where can we find the duties test?
There is no specific duties test, but you can find, if you just kind of Google any of these exemptions, administrative exemption, and look for the federal site, the Department of Labor site, and they'll give you as much as they've got. There's some examples that they'll provide and some of the duties they'll list and things like that, but there is no single duties test for each of these. That's one of the huge problems in trying to feel secure about making the right choice, is that it's just like the black and white. There is no black and white. It's going to be almost a person by person and a company by company audit and choice of what it is. So often you'll get certain positions, based on title, but I've seen a lot of small companies over title employees. They kind of give them this big title because they're not giving them a big paycheck. But it kind of defeats the concept then of using a title to help you decide if this is an exempt level position. You really do have to look at the responsibilities. And, if you talk with an attorney, they do have a form that they've used. I've seen it from a couple of different firms, and so it seems like it's a generic one between them. And you could, if you've got a company attorney or something, you could just ask them to, send you what they use to audit a position. And usually they'll give it to you for free because they make the money on then reading it and asking you questions after you've completed it. But it'll give you an idea of like how they structure the concept of it.
Got it. So if it's black and white, we wouldn't need these webinars, right?
No, we wouldn't. And but that means each exemption would be like, 500 pages long with, examples of every single kinds of position they could come up with. And it is a tough one because this is one where I've had more arguments with management than any other argument. Independent contractors were coming close there for a long time, but this is like an eternal one because even the employees feel, like I said, it's like a status symbol. Yeah. And they truly believe I need to be, in an exempt level position. And yet most salaried people, that are exempt would take an hourly paycheck any day of the week because of the amount of hours they often end up working. Right. So it is this weird thing, and I get so many that just want to make it easy. Oh, they don't want to have to fill out a time card. Oh, we just want to know that they're paid the same thing. But that's not a legal argument that's going to stand up in court at all. And right. That's the part you have to keep arguing about. It's not going to hold up.
Right. Well, thank you everyone for attending today's webinar presented by Heffernan. We will send information by email with instructions on how to access a copy of the presentation on our website. And thank you, CJ Westrick, for your time and expertise today. I know we went way over, and I appreciate your ability to stay. We hope all of the attendees found today's webinar to be a valuable use of your time, and be sure to join us on August 4th for Successful Separations. Thank you very much and have a safe day.